just laid this morning by the Honorable Chief Registrar. So we'll launch straight to this much-awaited occasion. It's a great honor to host and welcome in our midst the keynote speaker, Professor Patrick Lodge Otieno Lumumba, to this gathering. Can you kindly come forward? Before we begin, I would like to read to you a short profile of the professor. He has a longer profile, which is posted on your website. I know that because we treasure what he's going to say, I would like to take as little time as possible. Now, in brief, Professor Patrick Lodge Otieno Lumumba, popularly known as PLO Lumumba, is a distinguished Kenyan lawyer, academic, and public speaker, widely recognized for his eloquence and insightful commentary on legal and social issues in Africa and beyond. He is a globally respected legal scholar and practitioner. He has served in various capacities, including as Director of Kenya Anti-Corruption Commission, Director of Kenya School of Law, and Secretary of the Constitution of Kenya Review Commission. He has written and published extensively in the field of criminal and constitutional law, ethics, and leadership. There is not enough time or space to read out a summary of over 3 pages of his profile. I urge you to read his profile, which is posted on the JTI website. In a few words, Professor PLO Lumumba is a renowned Pan-Africanist, celebrated for his profound commitment to justice, integrity, and transformational leadership, making him a compelling figure in any discussion of transformation of the socio-economic system. Professor Lumumba is particularly noted for his advocacy for good governance, anti-corruption, and the rule of law. He often emphasizes the importance of ethical leadership in shaping the future of society. His speeches are renowned for their passionate delivery and intellectual rigor, often drawing on historical versions of former African leaders like Kwame Nkrumah, Mwalimu Julius Kambarage Nyerere, and in their context of their struggle to decolonize Africa. His talks encourage critical thinking and often challenges the status quo and mindsets, urging his audience to strive for excellence. His vision for Africa is one of empowerment, unity, and self-reliance. Professor PLO Lumumba is a powerful beacon for a better Africa. He inspires his audience to embrace their responsibilities as leaders and to contribute positively to society through integrity, innovation, and active engagement. I dare say that his message will resonate well with the theme of this conference, being positioning Uganda's judiciary to contribute to social and economic development. Please join me to welcome Professor Patrick Lodge Otieno Lumumba, Professor of Public Law and former Director of Kenya School of Law.
Thank you very much. Let me start by recognizing the Honorable the Chief Justice of the Republic of Uganda. Permit me also in the same vein to recognize the Honorable the Deputy Chief Justice, the Justices of the Supreme Court, the Justices of the High Court, and others who are in attendance, including retired judges. Let me say how humbled I am to be present with you this afternoon to share my thoughts on a subject which is as important as it is critical, not only to the Republic and the people of Uganda, but I dare say the people of the continent of Africa. The Honorable the Chief Justice lets you imagine that I have not immortalized my thoughts in writing. They will be ready for circulation, a document which speaks in sufficient detail to the issues that I will be adverting to shortly. When I looked at the theme of this conference, I asked myself whether I should narrow myself down. But I thought that the theme is in itself sufficient to constitute the essence of my presentation, particularly now in the continent of Africa. Africa as a continent is suffering from middle life crisis. And you can see that crisis manifesting itself in different ways. It manifests itself through different types of conflicts. Those conflicts are of different intensity. And one need only take a visual survey of the continent to see how troubled the continent is. Giving meaning to what I believe is Charles Dickens, who said in his famous book, A Tale of Two Cities, it was the worst of times, it was the best of times. Africa finds herself in that space. And she finds herself in that space because the post-colonial African Westphalian state is still historically in its very early days, with Ghana, the first sub-Saharan country to regain her independence, only about 70 years since she did so. The Sudanese are always quick to remind me that it is Sudan which regained our independence in 1956. But I am quick to remind them that at that time it was never considered a sub-Saharan state. And during that period, you honorable judges will remember that the judiciary has suffered in many ways. You will remember in Ghana, when Jerry Rawlings assumed power, he lined up judges and had them executed. You here in Uganda will remember when the administration of Idi Amin came into power, how the judiciary was dealt with. And you will remember a lot more vividly in 1979, during the transition from President Lule to President Binaisa, how Justice Wambuzi was dealt with. And one can go on and on to recount how judiciaries have been dealt with, calling into question what is the status of the judiciary in Africa. In the last few months, I've listened to a number of statements being made by African heads of state regarding the judiciary. In Kenya, I've listened to the head of state complaining about what he described as judicial overreach. Here in Uganda, in the month of November 2024, I heard Yoweri Kaguta Museveni, the president, saying, in reference to a decision regarding the parishes, that he would talk to the Honorable, the Chief Justice of Uganda, and remind him that Uganda does not belong to judges and lawyers. It belongs to the people of Uganda. 2 days ago in Tanzania, the President of the United Republic said at a meeting of judges that judges must remember that they are not demigods. In other words, what we are seeing is what one may call agitation and conflict of a very unique kind, calling into question what is the exact role of the judiciary in post-colonial Africa. And it is not only in Africa that one sees this. If you allow history to inform you this afternoon, and you go to the United States of America in the very first administration post the Declaration of Independence, and you remember these immortal words of Alexander Hamilton, who was the first Secretary of the Treasury of the United States between 1789 and 1795, he said, and I paraphrase, of the three arms of government, the weakest is the judiciary. It possesses neither the sword nor the purse. And because of that, it is weak. What it has are judgments which are hollow unless they be implemented by the executive. That was in 1789. And you who are Ugandans and East Africa will remember a young Ugandan lawyer trained in the Soviet Union in 1967 saying, Picho Ali, in the transition, which was then a very important paper, transition number 36, that he does not believe that the judiciary is independent. And in 1968, a man whom I came to know and visited in Mbale, the late Dani Wadada Nabudere, made a statement which has become immortal. He said, after all is said, I urge you to agree, and I agree with the Picho Ali, that there is nothing like independence of the judiciary, that the so-called independence of the judiciary is nothing but division of labor, and that what the judiciary does is to do that which is in the best interests of the economy and the ideology of the country. And he then went on to pose, but what is the ideology of a post-independent African country, which has inherited a system which is not rooted in his customs and his circumstances? This is the question that we honorable judges must confront today, because that is the reality. That, in my view, is the genesis of the crisis that informs African judiciaries. It is not lost on me that the subject that you want to address is how the judiciary can be useful in the social and economic transformation of Uganda, and by extension, transformation of the continent of Africa. But it would be remiss on my part and on your part if we did not contextualize that discussion in history. And we must remind ourselves that the states that we have, whether it be Uganda or any other country, are products of a process. They are products of Berlin in 1884 and 1885. They are products of personal and commercial interests. When King Leopold of the Congo created the Congo Free State, which we now know as the Democratic Republic of Congo, and later called the Berlin Conference, which was held under the aegis of Otto von Bismarck. And the countries that we know today were divided into the 54 odd states. Each one of them followed a system of government that was informed by the colonizers. So that when you look at the legal traditions in all the countries, if you go to the so-called Francophone, and Africa is the only continent in the world whose countries are still referred to in those terms, so that if you are colonized by the French, you are Francophone. And indeed, if you visit and you read the history of many of these countries, you will see that their judiciaries are informed by the French tradition of civil law. Equally, if you visit countries that were colonized by the Dutch, such as South Africa up to a certain stage, the legal tradition is Dutch Roman. So that you are in Africa, in South Africa, and you are saying, my legal tradition is Dutch Roman. Countries such as Uganda, which were colonized by the British, also inherited systems that were characterized by what is referred to as the common law. But whose common law? The common law was the tradition of the English people. So that you, honorable judges, when you are writing your judgments and we talk about the reasonable man until very recently we used to say is the man or the woman in the Clapham omnibus. Not the man in a taxi in Kawempe, no, in Clapham omnibus. In Kenya, until Madam CBCJ, as it then was said, that the reasonable Kenyan man is the man in the Pangani bus, we still said that he was the man in the Clapham omnibus. That is how mentally conquered we are, and we must never forget that in our unguarded moments, we who are seated here, our minds are conditioned to think in a particular way. You, honorable judges, will remember times without number when lawyers appear before you, when they are citing Mukisa Biscuits case, they are not as animated as when they are citing Conway versus Rima. They think that Conway versus Rima is the acme of learning. That is who we are. But yet, in our Commonwealth or common law tradition, and honorable judges will remember these words of Lord Denning in the Nyali versus AG case, where he said that the common law is like the English oak. When it is transplanted and taken into a different environment, it does not grow with equal exuberance as it would in England. The same was repeated by Lord Atkin in Conway versus Rima. And you can see how my tone changes when I say Conway versus Rima. So what one is saying is that we are a people who are dealing with a judiciary that is not autochthonous or homegrown. And that is the reality. Even the systems of governance that we have are not autochthonous. We are described as Westphalian states. And therefore we have an executive arm, we have a legislative arm, we have a judicial arm. And you remember when Uganda regained independence in 1962, it did so on the basis of a Westminster model constitution, what you call the Republican Constitution. In 1967, I believe, if my history serves me well, the administration of Apollo Milton Obote attempted to bring in a constitution, the pigeonhole constitution, which history tells us that even those who had not read it said it was the best constitution, particularly those who had not read it. This was an attempt to indigenize constitution to answer to the post-colonial state. In 1995, after the administration of the NRA, NRM came into power, you'll remember that they experimented with a system called the movement system. And the whole idea of the movement system, as I understand it, was to begin to indigenize processes. Did it go far enough? No, it did not. In 1995, therefore, the process, or rather prior to 1995, the Ugandans said, we are giving unto ourselves a Ugandan constitution. And those of you, and I believe all of you, have read Justice Odoki's book, in which he tells us blow by blow how they came up with the 1995 constitution, how they tried to make the different arms of the government be useful to the people of Uganda. How will the executive be useful to the people of Uganda? How will the legislature be useful to the people of Uganda? What kind of judiciary we'll have for the benefit of the people of Uganda? Because when we are talking about socio-economic transformation, in real terms, what do we mean? Let us unpack socio-economic. The African state is artificial. Artificial in the sense that Uganda has no less than 56 nations, which prior to the advent of the colonialists had their systems of governance. If you go to the Bunyoro Kitara, they'll tell you we had our own systems of government. If you go to the Batoro, they'll tell you the same. If you go to the Basoga, they'll tell you the same. If you go to the Baganda, they'll tell you the same. If you go to the Banyankole, they'll tell you the same. If you go to the Teso, they'll tell you we had our Emory Mori. If you go to the Acholi and everybody else, they'll tell you we had our own systems of the government, and then we were welded together into the thing that is now called Uganda. And Uganda, like all African nations, is work in progress. That work in progress is the one that wants to socially transform. Where does it transform and what does it become, that thing called Uganda? I remember as a young, inquisitive student of history reading, at one time, I think it was Napoleon or somebody else or Voltaire who said, with regard to the Roman Empire, he said the conglomeration that is normally referred to as the Holy Roman Empire is neither holy nor Roman nor an empire. The question is, our African states are still struggling. And when you want to transform them socially, you must do so with due regard to their diversity. If you want to make them the same, then you are losing the point. In other words, the Baganda are only good citizens of Uganda if their Bagandaness is allowed to manifest. The Acholi are only good citizens of Uganda if their Acholiness is allowed to manifest. The Basoga are only good citizens of Uganda if their Basoganess is allowed to manifest. If you suppress that, then they become a danger to the thing called Uganda. And that is what Professor Ali Mazrui writes in his book, The Power of Babel. Not the tower, the power of Babel. That this diversity can be dealt with in a manner that it strengthens us so that we have unity in diversity. Not the unity of the graveside where there is silence which cannot be interpreted, is unity of purpose. The question is this judiciary capable of doing it? Let me take the simple question of the institution of marriage. When we were trained as lawyers in the common law system, you'll remember us being told that marriage is the union of one man and one woman to the exclusion of all others. When Telford Georges, that West Indian, was called upon to convict a person in Uganda prior to independence, and the man was charged with the offense of bigamy, said that he would not do so because that is not in keeping with the realities in Tanganyika then. He refused to accept that African customary law is only good as it is not repugnant to justice and morality. Because the question, whose justice, whose morality? Because in some African societies, marriage is the union of one man and one woman to the inclusion of all others. And if that therefore is the case, we must have a judicial system that acknowledges that reality. The Kenyan constitution, and I believe the Ugandan constitution now contemplates that polygamy is a recognized institution, and that you can register. The Kenyan constitution allows it, that you can register, this is my wife number one, wife number two, wife number three. The only thing is that you must make a decision at the very beginning. In other words, if you think you can be or you may be polygamous, don't enter into a union that excludes you. Don't go to the Attorney General's chambers. Don't go to a church, because that then becomes monogamous until you divorce. But if you go to Basoga customary law, Jopadola, Allure, then you are good to go. I'm saying this because it is important, because when we talk about social harmony, this is what must be done by the judiciary. The other thing that I'll talk about is land. Land in the capitalist system, when they came here, they told us that land is something that is the basis of commerce. And they came here with the whole idea that our lands were not owned by anybody. So in Kenya, we have a famous case called the Mulwa Gwanobi case, involving the Jibana peoples. When the British wanted to subdivide land, the people told them that land belongs to nobody, it belongs to God. The British administrator said, yes, we know it belongs to God, but the British administers it on behalf of God. And that is the basis on which you then have it registered as crown lands. If that be the case, if you want to create social harmony, how do you deal with land in Uganda? Amongst the Baganda, how do you deal with what you call the Milo land? How do you deal with land that is owned by the kings in Bunyoro Kitara? How does it become a factor of production? Because you are talking about social harmony and you are talking about economic transformation. Because if you don't take this into account, then you are going to suffer. And let me give you a very practical example. The Lapset, which was to be the pipeline from Lake, I don't like calling these things Lake Albert, Lake Mutanzike, or Lake Bonyo, which you call Lake Albert. The pipeline was to move from that area through to Uganda, through to Kenya, and through to Lamu, Lapset. This is not said, but one of the reasons why it failed was because of compensation. On the Tanzanian side, because of the Nyerere doctrine of land, that land belongs to the state, there was no compensation, among other things. How do you deal with that? Because if you don't deal with it, then an economic project will collapse. I'm still talking about socio-economic transformation and the role of the judiciary. In other words, a judiciary must be a judiciary that is sensitive to the realities of the environment in which they are operating. If the judiciary is not separate and is not sensitive to that reality, then that judiciary will sooner become irrelevant and will be ignored by the executive without consequence. But am I suggesting for one moment that every executive fiat and diktat must be followed, that the judiciary must kowtow to the executive at all times or to the legislature? No. I'm not saying so. I am saying that what must happen is that it is incumbent upon the judiciary at all times to ensure that what it does is in the general good. But that begs the question, what is in the general good? What is in the general? Who is to be the judge of that which is in the general good? This is what your African presidents will tell you. The African president will tell you, I went throughout my country. I talked to the people. I was doing so on the basis of a manifesto. The people then elected me. And what I'm doing is in the best interest of the people. I told them that I would do this in land. I told them that I would do this as regards interest rates. I told them that I would do this as regards all critical areas of the society. And therefore, you who are elected by nobody, that's what they'll tell you. You who are elected by nobody, you have no business to tell me what to do. And if you doubt me, look at what is happening in the United States of America now. By dint of executive fiat, agreements that were long settled are being disturbed. Things which you thought were constitutionally settled are being disturbed. And the judiciary does not know what to do. How does the judiciary behave in such an environment as an agent of change? I know this is sensitive, but I'll say it regardless because I'm flying out later in the evening. You, the honorable judges of the Supreme Court, have just made a decision that a civilian should not be tried in a military court. There is what I call executive pushback, as is expected. The question is, did you make the right decision in accordance with acceptable international law? Yes, you did. Yes, you did. The question is that acceptable now? Politically, your decision is considered to be politically incorrect. In 50 years' time, you will be vindicated. And that is what warriors of justice must do at certain times. That which is unpopular now may much later be seen to be significant in the manner in which it pushes the agenda. I still have 20 minutes, so I have the luxury of some time. I'm told that I have 40, but I'll not be like the Pharisees who speak for so long that they are then ignored. But I want to remind you, when you are in high school, about decisions about laws. You remember a book that was written by Robert Bolt called A Man for All Seasons. And you remember in A Man for All Seasons, the chief character is Sir Thomas More, now Saint Thomas More of the Catholic Church. You remember that what happened is that he refused to swear to the oath of succession to allow King Henry VIII to marry Anne Boleyn. And you remember that King Henry VIII went to him and was having a conversation with him and telling him why his consent was very important. And he told him, Thomas, you are known to be honest. Norfolk follows me because I wear the crown. Cromwell follows me because he is a jackal with sharp teeth, and I'm they are lion. Then there is a mass that follows me because they follow anything that moves. Then there is you, who is known to be honest. And what he was saying at that time, when his son-in-law, Richard Rich, came and told him, you can say with your mouth what you do not believe in your heart. And this is what he said. Just as a water spaniel is to water, so is a man to his conscience. And he told Richard Rich, you are telling me to destroy all the laws in England in pursuit of the devil. What about when, after I've destroyed all the laws in England and the devil turns against me, what law will remain standing in England to protect me? And the essence of that story is that when you are making decisions or making laws, you must make the laws as if it was being interpreted by your worst enemy. That is also the wisdom in Henrik Ibsen's statement, the strongest person in the world is one who stands alone. In other words, at critical moments in history, it is critical that you stand for that which is good and right, because it was always good to be good and right at all times. And I believe that the judiciary of any country has that duty. The Ugandan judiciary 1995 has made many landmark decisions. And those landmark decisions, some of them have been popular, some of them have been unpopular, as it should be. But the question is, have they changed the Ugandan society in a fundamental way or in some way? My answer is they have. You are outside, you are insiders, so you may not know. When I look at your decisions in critical areas in the law of land, they are decisions that you've made and which have an incremental impact, which have been useful. When I look at your decisions that have dealt with issues in the area of climate change, there are some that have been useful in preserving the wetlands in this country. When I look at some of your decisions in the areas of the institution of marriage or commerce, they have expanded the frontiers. When I look at some of the decisions that you've made in the area of economic crimes, they have made a contribution to the Republic of Uganda. And I believe, therefore, that you have made your contribution. But you must never rest on your laurels, because the change in a society cannot be dramatic. You are not Moses in the Bible parting Red Seas and summoning manna to come from heaven and calling upon pillars of fire. It is incremental. But you know, let us ask ourselves, in the face of all that, you who are judges, let us ask ourselves a few fundamental questions beyond Uganda, because Uganda is not an island. How can you be agents of change in the context of East Africa? What is the value of your jurisprudence, for example, in matters of giving meaning to the treaty of the East African Community? What is your role in ensuring that when we talk about the movement of persons in Kenya and Uganda, what decisions have you made that is enhancing that particular situation? When we talk about tariff and non-tariff barriers, when there is a war in Uganda as to whether Lato milk should cross over or splash juice, I'm being very basic. What have you done in that area? And if you did that and dealt with the question of tariff and non-tariff barriers within the East African community so that there was ease of movement of goods in the 8 East African communities, wouldn't that transform the Ugandan economy? Your president once made a statement that I like and I repeat often. When Kenya, my country, was claiming to have the largest economy in East Africa, our GDP is slightly over 110 billion United States of America. Your GDP is anything approaching slightly 60, depending on who you ask. Tanzania is 80, and I think if you go to Sudan, is possibly 11 billion. Rwanda is 20 billion. Burundi is 6 billion. And Somalia, of course, is 2 billion. Those are our economies. And then he said, and this I thought was good, he said, you know, this debate amongst dwarfs as to who is taller than the other is not a useful debate for anyone. Because even once you have concluded that one dwarf is taller than the other, they are still dwarfs. And this one I added myself by saying, you see, when you tell a goat, which is doing very well, that when you eat very much, you'll become a cow, you are not being very useful to the goat. It can only be a fat goat. How is that relevant to what I'm saying? I'm saying that is relevant in the context of the decision that we make that inform the economy. As I'm speaking to you in Kenya, as at Friday last week, it was reported that there are cases which are packed in the commercial division which have frozen anything between 300 billion and 358 billion Kenyan shillings, decisions unmade, which, if they were made, would release that money into the market for commerce. You know, today, we are now talking about arbitration. How are we talking about arbitration? Because we feel sometimes that when we come to the regular commercial courts, then we are engaged in technicalities of procedure. And there are advocates who are experts at that. The jurat was not in the right position. The jurat was not in the right position. Not even the title, the parties were misdescribed. And for 1 year, you are talking about misdescription of parties and whether the jurat was signed and whether it was properly dated. And meanwhile, the subject matter of the case is 2 trillion Ugandan shilling. Should you cut through that? I remember at one time when I was a young and enthusiastic advocate and appeared before the Court of Appeal, which was then the highest court of the land, and I was waxing eloquent, telling the bench presided over by the then Chief Justice Bernard Chunga, and I was saying, my lords, you've got to look at substantive justice. I was then also a teacher of law. Then he asked, what is substantive justice? Then I tried to explain. He said, you go and do a proper affidavit. Because what we had done typically is that you'd made this or that mistake, you'd notice of appeal, not numbered, not paragraphed well. And of course, he was gracious to me because I was young. He said, I'm not going to strike out this application. Just go and repair it and come back next week. It is on that basis that subsequently, when we were making the Constitution, I think it Article 259 of the Kenyan Constitution, it says that no court shall pay undue regard to technicalities of procedure. And we are not killing the beauty of drafting. We are only saying that there are times when we must run away and ensure that procedure is truly the handmaiden of substance. I want to ask you, your leaderships and your lordship, when you are confronted with these issues on a daily basis, how do you deal with them? Do you ever imagine that if you don't make a decision where there is money that is being tied down, that is affecting employment in certain areas, that people could actually lose their jobs, that people could actually, the government is losing revenue because of a decision that you did not make, or that you have taken 2 years to make while you could have made it in 1 day? Permit me, your lordships, I now have 15 minutes and I'm consciously aware of time. There is a book that I read which I commend you to read. You may have read it a long time ago. It's a book by Chinua Achebe, Things Fall Apart. Chapter 10 in that book. If you remember, there is a trial in that book. It is somebody whose wife has run away, and he has gotten to the elders of the 9 villages of Umofia. And the chief judge, who would be the equivalent of his lordship, is called Evo Forest. And when the Evo Forest comes out, the first thing that happens, of course, I'm not saying that his lordship is Evo Forest. But when they come out, the wives of the chief character, Okonkwo, recognize that on that day, Okonkwo's chair was empty. And that one of the Igugus, one of the judges, walked with a springy walk. They do not tell us that it was Okonkwo. And then he comes out and addresses each one of the parties and says, the body of Zoulu, do you know me? Then he answers, how can I know you? I'm the dry meat that fills your mouth. The trial is conducted, and after a short while, they come and say, oh, first of all, he says that my wife left me and went to his home. And then the brothers come and say, this man beats his wife on a daily basis. Then they come after they have retired and they say, take your wife back to his husband. You don't beat your wife again. And I thought to myself, how could it be if our Supreme Courts would listen to the evidence, retire immediately and come back with a verdict and give reasons later? Of course, we would say that you are doing a very bad thing. But the point that I'm making is justice delayed is justice denied. And I'm also saying that is the reason why progressively we are also getting into the thing that is called alternative dispute resolution, which I prefer not to call alternative. I prefer to call them African dispute resolution methods. Let us change our nomenclature to what is it alternative? It is just African. And I believe that now the Honorable the Judge, who is the head of the Judiciary Institute, we must begin to change how we teach law. Because the ones that we are training are the very same that are going to become judges and magistrates, and they are going to transform our societies. I must now begin to conclude. And I'm beginning to conclude by saying that whatever decision that you make in terms of societal and economic transformation, even political transformation, must be informed by certain realities. You know, when I read certain landmark decisions or landmark instruments, one of them, whether you like it or not, is the American Declaration of Independence. It says in part, we hold this truth to be self-evident, that all men are born equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that it is for this reason that governments are instituted amongst men, that they may do certain things. And one of those things is social harmony. Now, one of those things is economic transformation. One of those things is political stability. So in your contribution, it is also important that although you framed this, I think for political correctness, you said it is only socio-economic transformation. I'm suggesting that it should have been more complete with political transformation. Why am I saying so? You cannot transform the society and the economy if you ignore the politics. And what is politics? Politics is the organization of human affairs for the general good. That is why you judges of the Supreme Court listen to election petitions. And you have had the occasion to settle election petition, that everything may happen, we may all vote, yet you have the power of a lion. that at the end of the process, you judges, the 9 judges of the Supreme Court, you can come and say that our votes were not cast in the proper manner, that the will of the people was not expressed, and you can strike down the entire process. We've seen it done. It was done in Kenya in the year 2017. It can be done. So that is how powerful you are. So the politicians may grumble all they want, but when they assume power, even when they assume power extra-constitutionally, my Lord, they look for you to swear them. They can't swear themselves. That is the reality. Even when there is a coup d'etat, the first person they are looking for is the Chief Justice. And if you are not a willing Chief Justice, they'll remove you and bring another one, but they look for a Chief Justice. That is how important it is that people want a semblance of legality, a veneer of legality. And it's the judiciary that does that. But the time is now that I think we must begin to interrogate our systems. Interrogate our systems in the context. The Ugandans must interrogate their systems in the context of East African community. There is the East African Court of Justice. His jurisdiction is delimited. When we were doing the constitution in Kenya, some of us held the view that we should never have created the Supreme Court of Kenya. We took the view that the last court of appeal should have been the Court of Appeal of Kenya, and then we create as an apex court, which would be the East African Court of Justice, which would be the appellate court, for I still hold that view. That as we integrate more, that is what is going to make sense. Because when that happens, my lords and your leadership, then you will not be susceptible to the pressures that you have when you are in Uganda, or when you are in Kenya, when you are in Tanzania. There'll be many other jurisdictions. Then political good manners will begin to set in, because you do not want to be the mannerless one in a larger East Africa. That is something that we should look at. The other thing that we must look at, for example, when we want to talk about socioeconomic development, is in the context of Africa. Today, we have the Africa Continental Free Trade Area, and we have the African Court of Human Rights, which sits in Arusha. Its jurisdiction is very limited. When we begin to talk about SCFTA, when we begin to talk about the movement of peoples, when we begin to talk about the Yamoussoukro Agreement on free air spaces, what kind of decisions are you going to make to ensure that we integrate your leaderships and your lordship and my lord? A friend of mine from Cameroon tells me something that I find ingenious. Perhaps 2 things. One, that the road to progress and the road to transformation, even by the judiciary, is always under construction. Yours is to play your part and hand over a sound judiciary to younger generation. That is all we ask you. He also tells me that changing society economically, socially, and politically is like eating the elephant. No matter how big your mouth is, you cannot swallow it. But if you choose to eat it morsel by morsel, in the fullness of time, 2 things will happen. The elephant will discover that it has been eaten, and you too will discover that you have eaten the elephant. God bless you.
Well, thank you very much, Professor Lumumba, for that insightful keynote address. I'm sure the audience is excited, and we can see from their reaction. We have spare time for the plenary. The plenary was supposed to be 45 minutes, but now we have additional 20 minutes. So we are going to take your questions and comments, and please be brief. I think not more than 2 minutes per person. We're not going to have another keynote address from the audience. We'll have comments. Five persons at a time to allow the presenter to address the issues. Yes, the matter is open. My Lord, the Chief Justice, your time is a little extra.
Thank you, Madam Chair. I would like to thank Professor Patrice Lumumba, named after the African icon, Lodge, meaning independence, Otieno, meaning he was born in the evening. I just want to thank him for validating the point I've always been making, that ADR to us is not alternative dispute resolution. It is African dispute resolution mechanism. Thank you so much. So makes two of us. Thank you so much.
I can see people are so satisfied, they are quiet. Maybe I can add my voice as the chairperson to the topic. Of course, socio-economic transformation, as far as the legal system is concerned, has something to do with regulations, apart from those dealing with the tariffs and the free trade. There is what was mentioned about timeliness of judgments. It has always been a goal for us to deliver justice in a timely manner and in a most efficient way, as far as possible, to have ADR, which is more of the justice of the people. Business people cannot tolerate delays because interest rates go up, many things go wrong, people are oppressed, etc. I think the legal, no system can do without a legal system that regulates behavior. People run to courts as a last resort, but this regulatory role at the level of the judiciary, I believe, is at the tail end when things go wrong. But if the system is working, I think most people would get on. I believe Justice Kirabwire has something to say. The microphone.
My Lord, I was just adjusting my microphone, but since you have challenged me, I'll rise to the occasion. Professor PLO, thank you very much for that eloquent discussion on how the judiciaries can really contribute towards socio-economic development. Politics is another issue. We'll deal with that on another day. The question that I want to raise with you is really not really a question, it's more of a comment I'd like to hear from you, is when you said, how can the courts then help not just to create socio-economic development in the country, but allow for integration also at the regional level? And my question arises from a recent decision from the Kenyan Supreme Court, with regard to whether or not in trying to fault the Supreme Court itself in the Martha Karua case, that it did not have jurisdiction to do so. Now, if the Supreme Court of Kenya, which belongs to a sovereign country, which has acceded to the East African Community Treaty, which has said that interpretation of the treaty with respect to those provisions is the preserve of the East African Court of Justice. And the East African Court of Justice has found that the Kenyan Supreme Court has failed in that regard, and says that its decisions will no longer have, do not have appellate effect over it, whereas it was really a decision at the regional level. What is your view about that? Does it not defeat itself? Does it not create confusion about the role of the courts nationally and the courts regionally with regard to integration? I hope I have put it in a clear way. Thank you.
Yes, Justice Kaitirima.
Thank you very much, Professor. Over time, there is a doctrine that has evolved, and I just wanted a comment from you. What we call the political doctrine question. That there are no-go areas in the judiciary that will have to be resolved by the politics. Or even if you are to resolve them, you will have to measure the political temperature. Do you believe in that doctrine? Or is it an escapist doctrine, especially for the judiciaries?
Yes, Justice Mike Chibita. Thank you very much, Professor Lumumba. So my question arises from the fact that you were introduced as a Pan-Africanist, and you also mentioned that maybe the topic should have been socio-economic and political. And then you mentioned a very interesting thing about comparing dwarfs. And of course, in light also of East African integration, I wanted to center my question around what's happening in Goma. And you see, the thing about dwarfs is basically you cannot be an island of prosperity in the Middle East. And we are in this integration. In other words, what's happening in Goma eventually is going to affect the entire East Africa and even wider. But I also wanted you to comment a bit about, can the law, the justice system, really work when there is political turmoil? Or if you are to advise this government, should they concentrate first on security? Is it, what would come first in order to safeguard the rule of law anyway? I hope in that convolution you can understand. Thank you very much. Yes, we shall take those.
Thank you very much, Your Lordships. Let me give my thoughts rather than answers to your questions, just my perspective. Let me start with the question of integration. And I think when we look at integration, there are different models. If you look at the European system now, which is a lot more integrated, one begins to appreciate that a decision that is made about the tariffs on tomatoes in Ukraine will affect a household in Lisbon, in Portugal. And I remember in my younger days, I participated in an organization called Friends of the Earth. And one of the cases that was filed then in 1994 was on the quality of water across Europe, just the quality of bottled water. And a decision was then made, which then led to the European directives. And if you go to Europe now, there is any bottled water, you will see something that is called European experience. I do not know whether you have water called Keringet in Kenya. If you have Keringet in Kenya, just read the label. It says European something. It was bought by Coca-Cola. Coca-Cola, Pepsi, and I think Nestle now own 40% of bottled water in Africa. Our bureaus of standardization, the Uganda Bureau of Standardization, Kenya Bureau of Standardization, Tanzania Bureau of Standard, pretend to have a standard, they have none. Those stickers you see are actually for revenue collection in most cases. And the reason why I'm telling you so, there was I'm answering that question. There is something called Lucozade. And many of you will have gone to hospital when you are sick people taking Lucozade, because it is meant to have vitamin E, or is it D, but some vitamin. You know, there is an organization that undertook research, and it was established that it did not have the things that it claimed it had. In other words, you will see that when you talk about, my Lord, you talk about the impact of activities in Goma. Right now, you go to the border and look at the cost of living has spiraled immediately. It will not be something, it is micro at that level. When, for example, the American president is talking about tariffs, he's just talked about tariffs against Mexico, tariffs against Canada, which have now been suspended for 30 days. Just this afternoon, the Chinese have also imposed tariffs because the impact is immediate. If you are buying this item, it means that in Uganda, if it was in Uganda, the school budget that was budgeted for by a high school principal and the school fees immediately is affected, which means you've got to go back into your pocket. In my rural home, which is not too far from here, can go by lake, half of the goods on our shelves are Ugandan goods, including eggs. The milk, the sugar is all from Uganda. And I'm quite certain most of it is just smuggled across the lake. But if we were to regularize that, and we say that there are no tariff and non-tariff barriers, then in the East African region, we would standardize. And if a case were to come before your lordships and you are to determine it, you would have a tariff system that is East African. As it is now, the courts are operating at cross purposes. Go to Sudan. The Sudanese are unclear as to whether they still want to go to Khartoum and have this law. If you go to the Democratic Republic of Congo, they are in SADC. They don't know whether to be with us or not to be with us. You go to Somalia, they have their own thing going their way. You go to Burundi, you have their own thing going. You go to Rwanda, so that the integration on the legal ecosystem is not supportive of the economic environment. And I am of the view that in terms of integration, we should harmonize the law. We have just concluded a case in the Court of East African Court of Justice in which you are involved, and the decision was against the government of Sudan. And once we had gotten judgment in default of their appearance, they have revived the case. And the argument against us is that our clients did not exhaust local jurisdiction. So the question is, you should have a uniform position in terms, must I exhaust local jurisdiction before I invoke the jurisdiction of the High Court? And if the local jurisdiction is hostile, am I left without anything to do? So these are systems that I think in the fullness of time, and I know that you, Your Lordship, and you have meetings of Chief Justices and meetings of Justices of the Court of Appeal and Justices of the High Court. These are the things that you should be discussing. Then there is what I call securitism. Securitism is when the political elite take the view that for purposes of national security, everybody should be aligned. And we have had cases of securitism in South Africa. The apartheid regime was underpinned by a judicial system. And I remember as a university student in third year, my then teacher, Oki Okombaka, asked us a question, is unjust law law? Because it is. So when the people say that at this time, we want the judges to be aligned, what do? When the president says, I will talk to the Chief Justice, what is he telling the Chief Justice? And if he talks to the Chief Justice, what does he expect after that conversation to happen? For a memo to be issued? Now this is the direction. I dare tell you that that is what he expects. But the question is, and I've always said that the executive and the legislature will always try to interfere. It is the duty of the judiciary to push back by force of reason and argument. And if you do that consistently, then you will discover that they begin to know that this cannot happen. So that it is also a sense of education to the political class by dint of your consistency in making the decision. And when later you meet them, they'll say, we tried, but you people are difficult. But if you succumb immediately, then they know this is soft ground. Then they come again and again. So I think that is very important, and I've seen in quite a number of cases in Uganda that has happened. And this is where issues of conscience arise. That if you are a bench of 9, sometimes I expect dissenting opinions, which are informed by a different perspective. Sometimes you may even arrive at the same decision, but from a different perspective. So it is becoming, as I conclude answering that limb of the question, my Lord, it's becoming very difficult in Africa because of what I call the crisis in what we call democracy, and because of increasing poverty and social disharmony. What we are beginning to see is that the executive arm and legislatures are becoming more and more aggressive. You've seen it recently in the election in Mozambique, how the court operated in legitimizing the victory of Frelimo. We have seen it recently in Gabon, and I think that is going to happen. So this is not a very interesting time to be a judge. This is not a time to be a coward if you are to be a judge. This is a time for courageous men and women, because we are going to do everything in our power to undermine, to malign, and to take your territory. But you are created for the job. Stand up. The question of the Supreme Court, I think you remember I said that one of the things that we, and many of you are there and have been involved in different ways, the Honorable Chief Justice, you've been around, all judges have been around. When we were doing the treaty, and I do not know if you have read the treaty for the fast tracking of East African Federation, the Amos Wako report, which says that we ought to have federated. In fact, the president of the East African Federation ought to have been sworn in the year 2010. The idea was to fast track the federation. So what is beginning to happen in the Supreme Courts is that Supreme Courts are thinking that the East African Court of Justice is eating into their territory. So there is a pushback as to what is a treaty question and what is a non-treaty question. And there are elements where you hold the view is that it is the duty of the East African Court of Justice to increasingly get into what I call creative interpretation of the law. This is how, for example, in Europe, the Spanish judges came out with what is called universal jurisdiction, where if you are a thief, an international thief, an order can be issued to arrest you in Spain, and you are arrested. I believe the East African Court of Justice should do that, but within limits, because when you are interpreting the treaty, the critical question is it a treaty issue? Is it an issue that is the reserve of the domestic arena? And in my view, if you interpret the law correctly, issues such as those should not arise, except, and I conclude answering my question with that, on matters of human rights. On matters of human rights, you must then interpret the Constitution in accordance with the African Charter on Human and People's Rights, the Universal Declaration of Human Rights, and the International Covenant. And in that regard, when you do so, you will discover that you have the capacity to expand the territory, but the local jurisdiction will also hit back. So it's going to be a push back, and it is not going to be easy. I'll conclude with this case, and I'm involved in the case which is sub judice. Two cases. I say them because I'm in the public domain as having written to the Chief Justice only last week, where the Supreme Court has barred a practitioner from ever appearing before them without limitation. So my letter to the Honorable the Chief Justice is this, is that if I am an advocate with a valid practicing certificate, and you tell me I cannot appear before you, and after 2 weeks you also say that advocates in my firm cannot appear before me or before you, are you not denying them a source of livelihood? And because it's in the public domain, those 13 advocates have filed a petition for the removal of the Chief Justice of the Republic of Kenya and all the 7 judges of the Supreme Court of Kenya. And this is my letter to the Chief Justice, and I'll tie it to the question that you asked. I said that if this particular practitioner has committed contempt in facie the court, ex facie the court, or has scandalized the court, charge him. Charge him so that he's tried, and you convict him and bar him or her for a known period of time. Otherwise, it is extraordinary and unusual punishment. And I say this because, once again, because of a letter I wrote earlier, we are meeting the Chief Justice on Friday with a view to discuss these things. And the other case, which is also sub judice, in which I'm involved, but I'll say because this is the public domain, the entire bench of the Supreme Court recused themselves. And when they did so, the decision of the Court of Appeal, which is alive, they say, we will not entertain your case, but the decision of the Court of Appeal, which is alive, will remain in force. In my mind, therefore, they have made a decision. We are in the High Court now, and I think the case is being mentioned on 6th, with a view to asking whether the High Court of Kenya is capable of making a decision on the Supreme Court's decision to recuse itself. Can the High Court of Kenya do so? And that we are going to argue. I think we are going to get a date on the 6th. And why do I say this in answer to your question? I'm saying this because these are difficult times. You have litigious, everybody is litigious, perhaps particularly in Kenya. Everybody is going to court on everything on earth. How does the Supreme Court behave? Some people are saying the domestic court, Ugandan court, no. We are looking to the East African Court of Justice. And they are going straight to the East African Court of Justice. What is the duty of the East African Court of Justice? To discuss those things in limine, issues of jurisdiction. And if it is obviously something that belongs to the domestic jurisdiction, let them be returned to domestic jurisdiction. But remember, regional courts also have sometimes very high appetite for expanding jurisdiction, because if they don't, they have very little to deal with. So don't be surprised if in the quest to be busy, they sometimes have unusual appetites. They forget that they are herbivores and behave like omnivores. So understand it in that context, my Lord. That is my perspective. And very finally, CJ, I can't agree with you more. Those of you, and many of you are arbitrators, we lawyers, we practitioners have destroyed arbitration. We thought that arbitration would be better in terms of quick dispensation. Today, you listen to us arguing before arbitrators. We have forgotten the role of administration. The same things we do in courts are the very same thing we do. So arbitration is no longer as expeditious. Mediation and conciliation, I hope the mediators and conciliators are properly trained so that they stop some of our misbehavior, which also calls into question, how do we train lawyers? I now hold the view, Mr. Chairman, that the time has come that law should actually be a second degree. The reason why I hold that view is because I've seen people who come to the law. In the older days, it was today, you find young people, some of them are very good, but some of them are lawyers because of the unfulfilled ambitions of their parents who couldn't be lawyers. But if somebody has a BAc or a BA or a BCom, the level of maturity that they bring to the legal profession, and we now have enough lawyers, so we won't die. If, for example, Uganda were, and I hope that this will be an East African decision, that from the year 2030, no university is admitting fresh high school students. Easier said than done, once again, because of politics, but I look forward to those days, because if it is not difficult, it is not worth doing. Thank you, my lords, and your ladyship.
Yes, thank you very much, Professor Lumumba. Though we have a bit of time, I think this brings us to the end of this session. I would like us to give the professor another round of applause. I believe that at this juncture, I can hand you over to the presiding officer. Thank you.
Thank you very much. Let us give another round of applause to the chair and another bigger one to Professor, our presenter. I think we agree that is the highlight of this conference so far. And my Lord Chief Justice, the DCG and PG Emeritus, and the retired justices and judges were very excited. At least they were behind me, and they were like, if this was an elephant, it has actually been eaten, and they are satisfied. So thank you so much, Professor. You have done justice to this paper. After lunch, you have kept us all awake and very excited. Professor, the Honorable the Chief Justice has a gift for you. And I now invite the Honorable the Chief Justice to present that gift on his behalf and the Judiciary of Uganda, just to say asante, or is it walwaswa, being very near that border. Wafoyo. Thank you very much. Thank you so much, my Lord. Let us appreciate the Honorable Chief Justice for that.
My lords, I was reminding Professor Lumumba, this is the second time I am having the privilege to invite him to Uganda to speak. The first occasion was as chair, Board of Trustees of the International University of East Africa in Sanga a couple of years ago. I invited him to come and talk on the date of our graduation. And then I've had this second opportunity. And as you've seen, he never disappoints. Thank you so much, Professor.
Thank you so much, my Lord. And journey mercies to you, Professor. Thank you. I now invite PRO to invite the next chair or advisors to stretch a bit, and then we proceed. Thank you.
Yes, Your Worship Faizo. Please, as usual, you know those tricks. Everybody has his role, and this is yours. Please come and we do some a little exercise as we prepare for the next presentation, which is on fitness. My lords, we are going to have just some 2 minutes of some.
But the next presentation is an exercise. Why don't we go there directly?
Yes, my lord. Yeah, but there could be preliminaries, my lord. Let us stretch a bit. Some appetizer, my lord.
Thank you so much, PRO. My lords, humbly praying that we stand up and get some space. We are going to do some bit of dancing. And yesterday they talked about calligraphy. I and my sister here did practice how to dance. So we shall be demonstrating how to dance. You'll be picking the calligraphies from this side. Then you'll be dancing from wherever you are. And I wish you good luck. Please ensure that you have somebody to pair with. You can see me with my sister here. Yes. DJ, let's go. Thank you so much.
You see, that was wonderful. My Lord Chief Justice, allow me to invite the chair of the next session, Honorable Justice Anna Mugenyi Vitature, to come and take up the seat and proceed to invite the next presentation. My Lord. I've been asked to remind you tomorrow we have tomorrow we have a cocktail and we want you to dress down. The dress code for tomorrow is smart casual, can do kitengi, African, be smart so that you are able to enjoy the cocktail party courtesy of the Honorable Chief Justice. So please, tomorrow you come with your smart casual so that we can have it. My Lord, you can take over.
Thank you, Your Worship. My Lord, the CJ, the Honorable Chief Justice, the Deputy Chief Justice, allow me to follow the protocol, to adopt the protocol set out by the Chief Registrar this morning. Good afternoon. My role is to chair yet another exciting and inspiring presentation on physical exercise for a healthier and happier life. At this juncture, I would like to invite Mr. Sebugwawo, the presenter, to come and take his seat. You're welcome. Please take your seat here. Come this. Robert Sebugwawo is a Ugandan who has been based in California for the last 20 years. He's a preventive health specialist, economist, published poet, writer, health coach, nutritionist, physical fitness expert. He's currently working with the Parliament of Uganda as a fitness and preventive health expert. He earned his, over the past 2 decades, he has worked on a wide variety of professional capacities in both the public and private sectors. He's a retired bodybuilder, competed globally from 1996 until 2008. He's a registered member of Exercise in Medicine, global organization based in the US. He's a global physical activity and nutrition champion. He earned his Bachelor's of Arts degree in economics from Makerere University. He has other qualifications at diploma level such as fitness and nutrition, paralegal studies, sports nutrition, and health coaching, which he earned from the USC University in California in the USA. Robert has recently been a physical activity consultant with the University of Southern California Institute for Global Health. He has done global health promotion effective work for the last 10 years. He also spearheaded the establishment of the fitness gym in Parliament of Uganda that was officially launched in 2011. He's also a valued youth motivational speaker and a proactive champion for physical activity for better health and lifetime well-being. He regularly makes presentations in workplaces, schools, churches, universities, law enforcement agencies, Rotaries, sports communities, government ministries, and international private education institutions. He loves reading, sports, social interactions, and volunteering for global causes. He's a family-oriented man, blessed with a wife and children. Robert is a Rotarian from the Rotary Club of Kampala Central, and he's serving on board as the Sergeant at Arms. He's also the fitness team leader in District 9123 and currently serving on the Cancer Run Team 2025 as the chairman for Venue Committee. Please join me in welcoming Robert as he makes this exciting presentation to all of us.
Thank you for that kind introduction. I'll stand on our protocol observed before, but I'll first give my honest thanks to Your Lordship, Honorable Chief Justice, our Chief Registrar, and the entire organizing committee for inviting me here to share a very important human message that we all need. Usually, fitness and health are factors that are neglected, but I'm very happy that this time around, the Judiciary conference organizers have realized that this is very, very important. My presentation will be brief, but I know that you enjoy whatever I will share with you. And I'm talking with authority that I'm going to share with you ideas that I've personally or that I personally practice. As you can see, the message is very simple. And I'll start with this statement. It's scientifically proven that people who are physically active are less likely to suffer from chronic diseases such as heart diseases, type 2 diabetes, and some cancers. Physical activity can help individuals of all ages to lead not only a healthier but a happier life. So, as we proceed, the images, I'm very mindful about your very busy schedule and what you go through every day to accomplish the national work. So as I was coming up with my presentation, I decided to bring images that I believe you can apply in any setting where it's safe for you to keep fit. So if you look at those images there, we assume you've spent 6 hours on the bench and then you go in your personal office. Please spare 5 minutes and move your bodies the way you see how those images indicate. It's very, very important to allow effective blood circulation after reading, listening, doing research, and then make interpretation of the law. I'm assuming I'm a judge, and I'm in a court which has sat since 8 a.m. up to midday. Those are 4 hours. It's too much. It's really too much. And scientifically, we believe that our bodies are created to move. In the modern world, we are being faced with transportation that doesn't allow you to move. It's not like bicycles in the traditional society. And we have technology where you're going to sit on your laptop and stay there for 6 hours. And we have borders. We have elevators. It's my humble appeal to you all that please be mindful about regular physical movement. You see, typical sample physical exercises for an audience, a profile like you. You assume you've gone in your private office and you've seated like that, as the gentleman you see there. That won't stop you to move your body. The way you've seen the good judges came in here and danced, that was very good. What are we trying to say by that? But you get your 5 minutes break and you dance the way they danced, you're allowing your body to be active. And it's very important. Now, you see, we assume still we are in our private settings. And we don't have time to go do this in any other place. Those are some of the images that you can go ahead and use to make sure you're physically, mentally steady to serve, and even to polish your intellect. We totally believe that if your intellect is not sharpened, you won't critically think to make wise decisions that are expected out of you. And all this based on science. We are there. It's my humble appeal to all of you in your respective capacities that you will talk to your superiors and tell them we need active breaks. The dance they have just here is an active break. So take a walk. I assume you are at High Court. I assume you are the High Court, and you see number one image there. You're going to take a walk with your friend, and it could be a team, and say, let's take a walk. But this is a mindful walk to keep your body active, and it's very beneficial to your mind and brain as well. You can climb stairs. Please try to forego the elevator. If time is not after you, or when you're not trying to chase time, and you have some 20 minutes before you get to your busy program, please take stairs, because those stairs will help your cardiovascular system, the organs that you don't see, so that you don't start panting when you go over something that is very tasking. Still, I've seen that at the High Court, Dr. Bijirimana has come up with very good ideas of having 2 gyms there. In my last 5 minutes, I'll give the operator of Fab Wellness to share with you the services that they provide in those 2 gyms. Please utilize them. And we do have yoga. Still, you're doing all this in your private setting, because, like I said, I'm very mindful about your profession. And I know what it means that most of the time you spend them in private settings, which is very okay. But we are not saying that because you spend your time in private setting trying to do productive things, don't keep your bodies active. It's very, very paramount. And I want to share this with you. Be the primary doctor to yourself before you go to Molago or Chirudu. Because if you're the primary doctor to yourself, you will know how you manage your high blood pressure. What should you do? Your blood circulation will be in order. You know how your organs function, so that you avoid the issues of non-communicable diseases that I mentioned earlier. Now, it's not only about moving your body, but we want also to master your nutrition, which I believe that Dr. Kasanene has shared information with you that it's very important to be mindful about what you put in your body. And if we try to copy a few things from the traditional society and the rural areas, that people in rural areas unconsciously eat healthy food. They live active lives. It will be very rare to get people in rural settings to get lifestyle diseases. It applies to the traditional society. Our ancestors used to move more, ride bicycle, walk, dig, and all those activities. Still, we are talking about those wellness initiatives. Make sure you get time to get adequate sleep. It's a balanced lifestyle act you need to practice. I totally believe you're very, very busy. But the only way you can manage your busy lifestyle and not get lifestyle diseases is you by understanding that it's very important to you to live a balanced lifestyle, but knowing when should I exercise, what should I eat, at what time should I rest, and you should also have boundaries. You're not a machine. We are all human beings, and we have 24 hours in a day. So it's very important that we handle that. Purpose of physical activity. I'll go through quick. Mental and emotional benefits. Science tells us that people who exercise, their emotional intelligence is higher. And that's something that you, as high-level law interpreters and fact masters must utilize. You see that? I brought in those images to show that images to show you that even busier people like the former president of the United States, Barack Obama, get time to stay active. And I brought in President of Kenya, you see him there. Then still, you see President of Kenya trying to demonstrate the push-ups to the public. That is very important. And still, you see there the former President of Kenya trying to get active. So what am I saying? That in any space where you are, you can be active. So I humbly appeal to you all that it's not about the space, but it's about the options. What am I trying to emphasize? Try to get something, any physical form of physical activity that works for you. You can walk, you can jump, you can ride a bicycle at home, you can do shadow boxing, you can use a treadmill, you can do anything that moves your body. So it's very, very important. You see the image where a lady is seated in the office and she's trying to raise her hands to stretch. That is very important because I don't expect you with your busy schedule to go in the gym outside the parameters, the good things. Still, let's clap for Honorable Chief Justice and Chief Registrar and PS for providing the 2 gyms that you have at High Court. Let's clap for them, please. Because they thought it right that by bringing those gyms to you, it will be accessible. And as the lady, the director of Fab Wellness will tell you, all those 2 gyms have everything that you would need. I humbly appeal to you, Judge Thomas, please make sure you utilize that. You're my very good friend. Utilize it. Okay? It's free. You don't have to pay. Chief Justice and Chief Registrar and PS, they have already paid for that. You see that? During COVID, our president tried his level best to demonstrate simple movements within a home setting, within a short space where you can be and say, let me do push-ups, let me do this and that, just moving your body. So when you see those images there, the president is in State House trying to share the happiness of physical activity because it helps to regulate sleep patterns, improve sleep duration, and enhance the overall sleep quality. As we said, why do we do physical activity regularly or daily? So that we can be healthier. All of us in the world want to be healthier and enjoy our money. That's why the topic says physical exercises for a healthier life and a happier life. No one wants to make money and then you're not happy. But you will not be happy if you have high blood pressure, if you cannot bend, if you can't move, if you can't laugh, if you cannot connect with your friends. The judges who came over here to demonstrate a dance, you saw they were happy, clapping hands, all that. That's what we need. That's social health. So it's still my humble appeal to all of you in your respective capacities that take physical activity as a lifetime responsibility because it's the best medicine that you get. And you see how President Barack Obama over there, you see all those are global icons. Why I brought those global icons? To show that they also have busier lifestyles like you. So there is no way, my good friend Judge Thomas, you say that I'm so busy. I've given you the blueprint and the prescription. You will be the role model of the judiciary community to say that if you exercise 20 minutes a day, it's very important. You see, when you do exercise, it leads to that, the social and functional benefits. Still, I'll go back to the dance that they demonstrated to us. I saw everybody in the audience. You are very happy. That's social connection, and we need it. And your lordship, I'll humbly request that at least in every quarter in your calendar, let's get an outdoor activity. We can ask Nambole, we can ask Lugogo, we can ask Nachivubo. And we have all the judges, we do something. Outdoor. People will take something home and it will be a good habit. Doing physical exercise is a very good lifetime habit and a behavior that you can't regret. And I know you know that, Your Lordship. Still, why I was biased to bring those images to show you that in any setting where you are, assume we are outside over there, when you know the body movements you can use, please just make sure you see President Barack Obama is demonstrating push-ups. So try to get space, try to get time. I would say prioritize this physical exercise. Okay, still, those are the same images as well. Those are the same images as well. What did I say in that? Those are two former presidents of the United States. Even at 82, President Biden could move. And what does that say? Enhanced productivity and creativity. Exercise can improve work performance, which I believe, Your Lordship, is what you want from your judges. Right? So that there are no time lag in whatever they're doing. And overall productivity is very important for all of us human beings. It's my humble appeal that when you adopt or when you modify your behavior and you take on physical activity, you will never regret, but you'll be the best of yourself. Do you know some of those people there? Do we know some of those people there? We see PS Dr. Bigirimana trying to show the entire judiciary community that for him to be a performer he has been, or who is still being a good performer to the nation of Uganda, you need to get active. He was outside your high court demonstrating the run, how people can run. And who was the chief guest during that? Chief Justice. Thank you for leading from the front. And it's what I want to humbly request you, that if we can get quarterly outdoor workouts, it will be very important. And you see, you know the new president of the United States, he plays golf. That's part of what helps him to stay steady. Golf is a physical activity. Why did I bring it? To show that if your schedule is so busy, at least get involved in golf. I remember when the chief guest of the day today, my boss, Speaker of Parliament, came over here. Before she spoke to you, she said, why don't we stand up? Because that's the culture we've adopted in Parliament. That we know any human being, when you sit for more than 90 minutes, you're going to start getting issues within your body. Not only your body, but even your brain. So we've made it a habit and a behavior, good behavior. That's why you see that in her caliber, she could tell you, stand up. So it's important that wherever you are, in your own settings, let it be up country, let it be here, you must make sure that you embrace the most important behavior for all of us human beings of staying fit and active. You will never regret. You see? The middle for the ladies, that's what it means. She's a former first lady. But she took a campaign of engaging all the young ladies and all ladies in different ages to show them that for them to be happier, to be productive, to be healthy as she is, she works out. So that's why I brought that image to show you that even at that high profile of global scale, you can do something to make sure. And you see the good gentleman hugging, doing golf. It's very, very important. And that's why I said that everyone can find any form of physical activity that can help you. Thank you. And before I close out, these are a few things that I want to share with you. Can you write down this website and you spare it on your phone? It's www.exerciseismedicine.org. www.exerciseismedicine.org is one word. When you get a chance on a regular basis, visit that website. It will give you paramount tips on knowing that even though you go and get pharmacology from your physicians, still you need exercises, because the medicine would not work well if you do not have, if you're not doing exercise. So it's very important. And as I close, before I give the 5 minutes to the Director of FAB Wellness, who takes care of the 2 gyms at the High Court, these are a few things that I want to share with you. That moving more is a daily habit for good health. What do I mean moving more? I can be in one space like this, I'm moving. You see? Assume I'm in my office. I'm moving. Not even running, but I'm in one spot. That helps my physicality. That helps my inner organs that I don't see. But I'm moving. I stop in a minute, I go. Sigh. 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 I'm assuming that I'm a judge at High Court. And I'll finish my 4 hours, right? So I can't have an excuse. Okay? And please, please utilize your insurance. Go for regular medical checkups to know your status. To know your status. Okay? Now, let me use this opportunity to invite Madam Lee, who is in charge of FAB Wellness, handling the 2 gyms at the High Court, to share with you the packages, the options that they have for you that are underutilized. Thank you.
Good afternoon, honorable members of Judiciary. Just a few things. We run or manage the gyms for Judiciary at Court of Appeals and Supreme Court. And we would like to invite you to utilize these facilities, because our PS for Judiciary has put his heart and soul in to make sure that the priority in the health of Judiciary is paramount, because healthy bodies create healthy minds, and healthy minds create healthy lifestyles. So I don't want to talk to you. Our coach has spoken to you about a healthy lifestyle, so let's just talk about the gym. We have very professional, highly trained trainers. This is our operations manager that's based at the gyms for Supreme Court, Court of Appeals, the 2 blocks. But I mean, all judges are welcome there. It is free. This has been put in place for your health. You can go there, you can work out, our trainers will help you create a program according to your lifestyle. We're not asking that you come and run and work out like a 30-year-old. It's not possible. We work out according what you need, whether it's stretching, whether it is cardio for the younger, whether it is just walking, whether it is just movement, mobility, because we can grow up, or we can achieve the age of 80 or 90, but we can't get out of a chair. So we want to enforce this, that we will help you mobility. So it can make you a strong senior person and not a fragile senior person. We have steam and sauna, highly effective for stress management, for detoxification of your body. We have massages. So you can come and join any kind of, we have medical masseuses, we have relaxation masseuses. All this is for free. You can come in talk to our trainers, talk to our operational manager. We also do full comprehensive nutritional projects for you. We sit down with you. We look at your health. Do you have knee pain? Do you have high blood pressure? Do you have some kind of just sitting down creates swelling in our knees and in our feet? What can we do to give you the tools? We're not asking you to eat salad the whole day. We will look at you, look at your lifestyle, and work something out. We just give you tools how to eat, what oils to use, how food to mix, what herbs to mix to give your life optimal health. So we ask that you come once a week, start with once a week. Let us work out the program for you. We want to do a program according to your hormones, according to what you require, according to your ailments, where you are in your life. We are not going to push you into something that you cannot manage. So once a week, come for a training, whether it's a light training or a walk, come for a steam, come for a massage, because a healthy body creates a healthy mind. It helps us with focus. It helps us with mental clarity. And this, you are the leaders of our nation. The choices and the decisions that you make every single day it's literally life and death sometimes. So if we can help you, give you the tools on managing your stress, managing your workload by becoming a little bit more healthy, that's what we are there for. That's why Judiciary has put these services in place for you. So this is all free. All we ask is come and look at it, come look at our programs, and let us assist you. Come join us, become a healthier, nurturing member of the leadership of Uganda. And through that, we will have the example of the people that's in our communities. We can set the example of what health looks like, because health is not only fitness. Health is mental. It is nutrition. It's how we live, how we sleep, how we work. Do we overwork, or do we sleep, or do we not sleep enough? And if we sleep, do we get quality sleep? Because it doesn't help having 6-7 hours sleep, but you can't achieve deep sleep. And that might be something as small as a nutrition. We might see in your blood test that you are vitamin D deficient. And vitamin D can cause high blood pressure. Vitamin D can cause aches and pains and joint problems. And all you have to do is get a little bit of a vitamin D into your blood, and those ailments can be rectified. We have fully nutritionists on board. We have doctors on board. And all this is at your disposal. There are additional services that we offer for kitchen pharmacy, where we go and teach the people that cook for you how to cook healthy, what oils to use. We're not saying don't eat potatoes, don't eat matoke. We just say, how do we eat it to make you healthy, more optimal in your energy, so you don't feel a crash in the afternoon. And 3 minutes, okay. Well, I hope this will invite you to come to the gyms, join our program, come see for yourself what it's about. It's on the 6th floor of Court of Appeals, Supreme Court. We operate Monday to Fridays, 6 a.m. to 9 p.m., Saturdays, 9 a.m. to 1 p.m. So anytime, pop in, come for a massage, come for steam, come for sauna, and come work out with our trainers. Set up an appointment, we can do a nutritional program for you according to each and every person's, because we are all different. Thank you, guys, and I hope to see you there soon. Oh, yeah. Please join us on social media. We are Fab House UG, Fab Wellness UG. We give you tips on different vitamins, different stretches, what to do if you have ailments, what to do if you are in menopause or perimenopause, or you have hormonal problems, what to do if you are struggling with joint pain, what to do just without going to the full length of having a full exercise. Follow us. We give you tips. We regulate how your life can look like, how much water do you take, and then put a little bit of salt in your water that will help the absorption of the fluids in your body. And just follow us, and that can also give you a lot of information and education on health. And the company profile is in all the gift baskets that we've handed out. You can get more information from there, or just pull any one of us over or come see us at the gym. Thank you, guys.
Thank you very much, Robert and Madam Lee, for your presentations. I just want to assure you that I'm a live beneficiary of the gyms and the massage parlors at the Court of Appeal and Supreme Court. So what Lee is saying is very true, and I would encourage each one of us to give it a thought. Now, for the remaining 15 minutes, we will invite any questions or comments from the plenary, and then close the session. Justice Nshimye, Justice Keitirima.
I would like to thank His Lordship, the Chief Justice, and the organizers for this. I am also a beneficiary. In November, I had my annual leave, and I reluctantly dragged myself into the Court of Appeal because I think a doctor told me to go and see something. I can testify that I was well handled. I knew nothing about gyms. They managed to really handle me very well. The trainers are very good. I would urge everybody to go there. Sadly, my leave ended, and I used to go there every evening, I think between 4 to 5 for just 1 hour. My leave ending, I had to go back up country. So my question is it possible for the management of the gym and maybe the judiciary that with program where the members to the gym can use it, can extend hours to Saturday morning and Sunday morning, because that would allow those who are so busy during the week to utilize the weekends when traffic is less, and I think that would be to help us a lot. So I just wanted to give my personal testimony, but also make that request, and also to say I think it's a very nice initiative by the Judiciary of Uganda, the Chief Justice, Deputy Chief Justice, and the PS, and the team. Thank you so much. Yeah.
Justice Keitirima, please.
Yeah, thank you. I just wanted to know whether they conduct group exercises like aerobics, whether they have specific times where they conduct group exercises.
We shall definitely put the proposal forward for the weekend hours, and I'm sure they won't have a problem with this. And then we will let everyone know an extent, because health is your wealth. And if we can promote weekend workouts, it is in your benefit. So the group exercises are Tuesdays and Thursdays, 5 p.m. at Court of Appeals. So up to now, we only do 2, and if there is requirements or if you ask more classes, we are absolutely open. We are here to serve you. We are here to help you. So just put it forward to us, and we will address it.
Thank you, Madam Lee. Any other questions? I have a question here. I'm not sure who will answer it, probably CR. Are retired judicial officers entitled to access judiciary health facilities? CR, please.
My Lord Chair, thank you very much. They are more than welcome to attend and enjoy the health facilities. Thank you.
Any other questions? Okay, if there are no other questions, then I think we need, yes?
I have a question.
Yes?
Thank you very much. Uh, for a first timer walking in to access the services, what is expected of him or her? What should he carry? Thank you.
Madam Lee?
You can come with your exercise clothes. The rest is and your water bottle. You have water there that you can utilize. We have beautiful showers and change rooms and lockers. So all you come is with your exercise clothes. You can change from there, shower from there. There's water for your convenience, and have a water bottle. And if not, you can even get a water bottle from the gym. So the rest, when you walk in and it's your first time, one of our trainers will take you through the program. You can either decide, no, I know what I'm doing, and we will just keep an eye on you. Or we go through a system where we do like a program, see where your fitness level is, what can we suggest for you, what do you like to do. Maybe you like HIIT exercise, or maybe you like mobility and strength. We work a program according to your requirements and your medical conditions. Does that answer it?
Thank you, Madam Lee. The last question.
It is actually not a question, my
Okay,
lord.
yes.
I'm helping my brother Justice Okello. I'd also never gone to the gym, so I would advise him just to walk in and say, what kind of shoes do I need? I hear there are walking shoes and sports shoes. They also tell you the kind of wear you can have. That's what I did. I walked over to Cookie. I think Towers bought the shoes they told me that could work. I then bought something that looked like a tracksuit, which I took home, and my daughter rejected it. It is not fab. So then you can send your wife to help you get one. I'm sure you're married. So after some time, you'll be able to fit in. So I'm sure you're better than me. I was really in a worse state. Thank you so much.
Thank you very much, Justice Nshimie. If there are no more questions, please let's give a big round of applause to Robert and Madam Lee and close this session. Thank you very much.
Let us give an applause to the chair of the session. My Lord, thank you very much for sharing this last session of the day. My Lords, on Friday is the opening of the new law year. And I believe that after that ceremony, the gym is available. So anyone coming from up country, please visit and check out that wonderful facility that the judiciary has provided for us. Tomorrow, I want again to remind us that we shall have a cocktail, courtesy of the Honorable Chief Justice. Dress code, smart, casual, kitenge, African wear, name it. As long as it will be comfortable on you, let us dress down. One time I was asked to explain what dressing down is. I don't know. But to try to be a little free so that you can comfortably enjoy the evening. My lords, we have a cup of tea, and I think it will be good also to do justice to it. Let me give a closing prayer. Lord, our Father in heaven, we thank you for this day again. We thank you for all the persons that you brought us here to share with us. We thank you for the wise words and counseling that we have received. We know you have made this day and you know all that which is good for us. As we close the evening, as we move back home, give us all the protection and journey mercies to return tomorrow to still continue with the program. In Jesus' name I pray. Amen. Thank you, my lords. DJ, you can give us some melodies as their lordships can stretch a bit and have a cup of tea. Thank you very much.